Hello. Today, we're going to talk about law and obligations and contracts, specifically from Article 1179 to Article 1190. Let's proceed. Article 1179. Every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. So we have two kinds of obligations. We have pure and conditional obligations. When an obligation is pure, it is immediately demandable. A pure obligation does not depend upon or condition, or it does not depend a future or uncertain event. For example, D promised to pay C 100,000 pesos. So that obligation is demandable at once because it is not stipulated in the agreement when they will pay the obligation. And for conditional obligation, there must arise a condition. So we have here meaning of pure obligation. A condition is a future and uncertain event upon the happening of which the acquisition or extinguishment of an obligation. So for example, we have here D obliges himself to pay C 1,000 pesos if C passes the 2026 CEPALE. So the condition here is if C passes the CEPALE. So if C passes the CEPALE, an obligation is acquired, which is to pay 1,000 pesos. Now, we will proceed to the two types of condition, which is the suspensive and the resolutory condition. So when an obligation arises when a condition is fulfilled, it is called suspensive, arise. And when a condition is extinguished when a condition is met, it is called resolutory, extinguish. So here in this example, let's change the situation. Let's say that D obliges himself to pay C 1,000 pesos every month. Wait, where is that? Every month until C passes the 2026 CEPALE. So that means D has an obligation to pay C 1,000 pesos every month until he passes the CEPALE. So if C passes the CEPALE, the obligation now is therefore extinguished, and that results to resolutory condition. But here in this main example that we talked about earlier, we are talking about suspensive obligation wherein the obligation to pay C 1,000 pesos arose from the condition. A characteristics of a condition, it must be future and uncertain. It means that it must happen in the future and you must not know if it will happen or not. Second is past but unknown, which means a condition may refer to a past event unknown to the parties. If it refers to a future event, both its very occurrence and the time of such occurrence must be uncertain. And lastly is a condition must not be impossible. Okay, for example here, D obliges himself to pay C 1,000 pesos if C floats on Earth for 1 minute. Is it possible for C to float in 1 minute? For illustration purposes, of course it's not, right? Therefore, it is impossible, and it cannot be a condition. We talked about here earlier the suspensive, which an obligation arises, and resolutory, which means an obligation is extinguished. Now, we're going to talk about when is an obligation demandable. It is demandable when it is pure, which means it does not depend on an uncertain or future event. Second is when it is subject to a resolutory condition. And third is when it is subject to a resolutory period. Okay, a legal condition must be a future uncertain event. A past event can only serve as a condition if it is currently unknown to the parties, making the future acquisition of knowledge the true uncertain event that activates the obligation, which means a condition can only be called a condition if it is unknown to the parties. Okay. Article 1180. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. Well, we're going to talk about period. A period is a future and certain event, upon the arrival of which the obligation subject to it either arises or extinguished. So, as we talked earlier, a condition is a future and uncertain event. But here, a period is a future but certain, a future and certain event. Number 1. The debtor promises himself to pay. The debtor promises himself to pay when his means permit him to do so. The obligation shall be deemed to be the one with a period, because when his means permits him to do so, this is certain. In this case, the debtor's will is not whether he should pay or not, but he bound himself that he would pay. So he would not discuss whether he will pay or not, but he will discuss when he will pay, which is when his means permit him to do so. That means the obligation is now a period. If the debtor and the creditor cannot agree if the debtor and the creditor cannot agree as to the specific time for payment, the court shall fix the same on the application of either party. Okay, my guys. Okay, we have other cases, as when the debtor binds himself to pay little by little, which is like installment, as soon as possible, from time to time, at any time I have the money in partial payments when I am in a position to pay. So in this problem, the problem is not whether the debtor can pay or not, but it's about when he will pay, because he already bound himself to pay. Okay. Article 1181. In conditional obligations, the acquisition of rights, as well the extinguishment or loss of those already acquired, shall depend on the happening of the event which constitutes the condition. Okay. For example, let's say in the preceding example, A will pay C if C passes. Sepale. So, if C passes the Sepale, there is now an obligation, which means C, as the creditor, now has the right. He has acquired the right. Okay? Now, if A pays C until C passes Sepale, the obligation here is a resolutory condition, which means the moment C passes Sepale, there is no more an obligation to pay. Which means, in this case, if C passes, his rights are now extinguished. But in the first example, his rights is acquired. Okay, that's for Article 1181. Now we'll proceed to Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the condition obligation. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Okay. We have several classifications of condition. First is as to effect. We have suspensive, as we explained earlier, which the obligation arises, and resolutory, which the obligation is extinguished. Now, as to form, the conditions as to form is express, which is clearly stated, and implied, which is merely inferred or assumed. Conditions may also be classified as follows, which is as to possibility, a possible condition, and an impossible condition. As to cause or origin, potestative, which means the condition depends upon the will of one of the contracting parties. 1. And casual, the condition depends upon chance or upon the will of a third person. For mixed, the condition depends partly upon chance and partly upon the will of a third person. So here in casual, we are talking about chance or upon the will of a third person. Now, chance we have, so in casual we have upon chance or upon the will of a third person. But if we have mixed, it depends partly upon chance and partly upon the will of a third person. Gets for B it's or, and for C it's and for A is depends upon one of the contracting parties. As to mode, we have positive obligations, which is to do, and negative, which is not to do. As to numbers, we have conjunctive, which means there are several conditions and all must be fulfilled, and we have disjunctive, which means there are several conditions and only one or some of them must be fulfilled. Then we have divisibility. Divisible, it means it can be divided, and indivisible, which means it cannot be divided. Okay. Potestative condition. As we talked earlier, it depends upon one of the contracting parties. Okay, now we're going to talk about when suspensive condition depends upon will of debtor. If the suspensive condition depends on the will of the debtor, which means the conditional obligation is void. Where the potestative condition, which means one of the parties, which is only the will of the debtor, the conditional obligation is void because its validity and compliance is left to the will of the debtor, therefore cannot easily be demanded. Okay, let's go to the examples. I will pay you if I want, which means the creditor has no control over this. It depends upon the debtor if they want to pay the creditor or not, which means it is void because the obligation is not demandable. We cannot demand the obligation. And that's the preceding examples. It's the same. And we have the other situations where only the condition is void. Here we talked about conditional obligation is void. There we have only the condition is void. If the obligation is a pre-existing one and therefore does not depend for existence upon the fulfillment of the debtor of the potestative condition, only the condition is void, leaving unaffected the obligation itself. Here, the obligation is not imposed on the birth of the obligation but on its fulfillment. For example, D borrowed 1,000 pesos from C, payable within 2 months. Subsequently, D promised to pay C after D sells his car. to which C agreed. In this case, only the condition is void, but not the pre-existing obligation of D to pay C. So D and C agreed that D will pay C 1,000 pesos. And then here comes D said that he will pay C after he sells his car. But the sale of the car depends on D, whether he wants to sell his car or not. And that depends upon the will of the debtor. So only the obligation of selling the car is void, but the obligation to pay C is still valid. Okay. Where suspensive condition depends upon will of creditor. If the condition depends exclusively upon the will of the creditor, the obligation is valid. For example, I will pay you my indebtedness upon your demand. So let's go to the example here so you understand further. Okay, we have here this example, D and C. Okay, C says that you will pay me if I demand the payment. The creditor here is C and the debtor is D, right? So the payment is upon the will of C if he demands or not. Therefore, that is valid. The obligation does not become illusory. Normally, the creditor is interested in the fulfillment of the obligation because it is for his benefit. It is up to him whether to enforce his right or not. So it depends on him, it depends on C, whether he wants the payment immediately or after later. Now, we're going to talk about resolutory condition. When resolutory condition depends upon will of debtor. If the condition is resolutory in nature, which means an obligation is extinguished the moment a condition is fulfilled, like the right to purchase a sale with pacto de retro, the obligation is valid although its fulfillment depends upon the sole will of the debtor. The fulfillment of the condition merely causes the extinguishment of the loss of rights already acquired. The debtor is naturally interested in its fulfillment. The position of the debtor when the condition is resolutory is actually the same that of the creditor when the condition is suspensive. Which means that here in resolutory condition there is already an obligation, right? And when the condition is met or fulfilled, the obligation is now extinguished. Normally, it is okay that the resolutory condition depends upon the will of the debtor if they want to accomplish the obligation or the condition or not, because the debtor is naturally interested in its fulfillment. Now, we're going to talk about the second part of condition, which is casual condition. If the suspensive condition depends upon chance or upon the will of a third person, the obligation is valid. Here we have X is a building contractor, and he says that 10 years from now, let's say today is 2026, and within 2026 to 2035, if an earthquake occurs within this year, X is then obliged to fix whatever damages were caused during the earthquake, which means the obligation arises when an earthquake or when damage happens, which means it is a suspensive condition. Okay, next. Where S binds himself to sell his land to B if B wins a case which is pending before the Supreme Court. So the Supreme Court here is the third person, So it depends upon the third person whether the suspensive condition happens or not, whether B wins or not. So yeah. Then we're going to talk about mixed condition. If the suspensive condition depart partly upon chance and upon the will of a third person. Let's say, let's say earlier, okay, we have X, a building contractor, in 2026 up to 2035. If an earthquake happens, if earthquake, and if there is defects in the construction, X will be obliged to fix the damages to Y. So let's say example, in 2027, an earthquake occurs. But then, we didn't find out that there were defects. There were no defects. Therefore, X is not obliged to fix the damages because the condition is if there's an earthquake and if there is defects. So the earthquake here is the chance and the defects here is the third person. So if both is not present, then X is not obliged. So here, if the obligation depends partly, okay, so like 50% from the debtor and 50% upon chance or upon the will, partly on chance or a third person, the obligation is legally binding. However, if the debtor has like dominating control over the condition, which means the obligation will be void. So they must be like equal. There must be an equal control. Okay. Now let's proceed to Article 1183. Impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by an impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Okay, let's say C pays D if D kills E. So the condition here is to kill E, right? Which means this obligation is not valid because killing E or killing in general is prohibited by law or those contrary to good customs or public policy. For example, we have another example. C will pay D if C will pay D if D kills E or if D sells his car. So we have two conditions here, right? Killing E and selling his car. So only the condition of killing E is void. But selling his car is valid, which means if he sold his car, then C is now obliged to pay him. But killing is not encouraged, nor like killing is discouraged, okay, because it is unlawful. The obligation is not valid. Article 1183 refers to suspensive conditions. It applies only to cases where the impossibility already existed at the time the obligation was constituted. If the possibility arises after the creation of the obligation, Article 1266 governs, which means before the obligation was constituted, the impossibility already existed. Like this, killing E already existed, which is impossible, even before the obligation to pay C arose. Okay, we have two kinds of impossible conditions: the physically impossible conditions, just like I said earlier, like floating for like 1 minute, that's physically impossible, theoretically. And then we have legally impossible conditions, when they are contrary to law, morals, good customs, public order, or public policy. Like what I said earlier, the one like killing A, that's legally impossible. Okay, now we have effect of impossible conditions. Conditional obligation is void. Impossible conditions annul the obligation, which depends upon them. So just like I said earlier, killing E makes the obligation to pay D void, makes the obligation void, because it is impossible. It is legally impossible. Conditional obligation valid. If the condition is negative, that is not to do an impossible thing, it is disregarded and the obligation is rendered pure and valid. For example, A pays B if B does not kill C. So we know that killing C, or like killing in general, is legally impossible. So does not, which means that it is a negative condition, like not to do. And if it is like this, if the condition is negative, that is not to do an impossible thing, it is disregarded and the obligation is rendered pure and valid. Therefore, if it's like this, to not do an impossible thing, the obligation is valid. Only the affected obligation is void if the obligation is divisible. The part thereof not affected by impossible condition is valid, which means killing Raphael is not valid, but this is valid and this is valid, which means only this is void. Okay, only the condition is void. Obligation is a pre-existing obligation and therefore does not depend upon the fulfillment of the condition, which is impossible. For its existence, only the condition is void. For example, D borrowed 10,000 from C. If C later agreed to kill X before D pays him, the condition to kill X is void, but not the obligation to pay C. So we have two obligations here. The one to pay C and the other to kill X. So to kill X, this condition is void, but the pre-existing obligation to pay is valid. Okay, Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. For example, D obliges himself to pay C 1,000 pesos if C passes the CEPALE on or before November 30. So, if C passes the exam on or before November 30, then D must pay 1,000 pesos. But if C fails, if C fails the CEPALE, then D is not obliged to pay. Okay, now if ever, example, the CPALE is on November 30, right? The results on or before November 30. If example, the CPALE exam is moved to the next, if example, the CPALE exam is moved to the next year for like March, then the condition will not happen, right? Because it is impossible for C to pass the CPALE on or before November 30 if the CPALE is gonna happen next year. Therefore, there is no obligation. The obligation is extinguished. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. D obliges himself to pay C1000 if C does not fail the CPA board exam on or before November 30, 2026. So, if on November 30 C passes, then D must pay 1,000 to C. So, on or before November 30, D is still not liable because C has not yet failed the CPALE. Okay, C takes the examination. Okay, C passes the CPALE on or before November 30. So on December 1, 2026, the obligation of D to pay C is now effective, which means it is a suspensive condition. The condition arose. Okay. So on November 15, 2026, the Professional Regulation Commission officially cancels the examination due to an administration and postpones to 2027. So we go back to the obligation that D obliges himself to pay C if C does not fail. So C cannot take the CPALE on or before November 30, which means C cannot pass, nor C cannot fail. Therefore, the condition does not fail is met. So, D must pay C 1,000 pesos because it is a negative condition. Okay, now we're going to talk about from Article 1186 to Article 1190. Article 1186. The condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. So we have three requisites. If the condition is suspensive. Second, if the obliger actually prevents the fulfillment of the condition. And third, if he acts voluntarily. For example, D is obliged. D must pay C if C passes the CPALE. So if C passes the CPALE, then D must pay C, let's say 10,000 pesos. So we have the first requisite here. The condition is suspensive. The obligation to pay C arises when the condition is fulfilled, which is to pass the CPALE. Okay, let's say before going to the exam room or the testing center, D deliberately throws out or like burns C's paper, like the paper that he needs to have to enter the testing room. So now when C enters the testing room, he cannot now take the CPALE because he does not have the paper, which means the condition to pass the CPALE is now prevented, which is prevented by D. And then Article 1186 states that if it is prevented, then the condition shall be deemed fulfilled. Therefore, the moment D prevented C from fulfilling the condition, the obligation is considered fulfilled. Therefore, D should pay C 10,000, even though C didn't pass the SPALE because he prevented the fulfillment, which means he is now obliged to pay C 10,000. Okay, next. As to resolutory condition, let's say here D pays C 10,000 if C passes the SPALE. Let's say C no, let's go to the other let's say D pays C 10,000 monthly until C passes the SPALE. Okay, so here comes C burns his documents, so he cannot enter the testing center, which means C prevented himself from passing the SPALE. C, or the creditor, prevented himself. So here in the resolutory condition, if C did that, he is now the condition is now deemed fulfilled. Therefore, the obligation to pay C 10,000 pesos monthly is now extinguished because C prevented the condition. Okay? So, in suspensive condition, Article 1186 applies if the debtor prevents the fulfillment. But if it is a resolutory condition, most likely if the creditor prevents the fulfillment. Therefore, in both situations, if the condition is not fulfilled, is prevented, then it is assumed or deemed fulfilled. Okay, we have Article 1187. In Article 1187, let us remember the principle of retroactivity. Okay, retroactivity means looking back in the past. Okay, let's say D gives C land and C gives D 10,000. If C passes the SPALE on November 30. Okay, let's say the day they agreed about this condition, it is on August 1. Okay, so on August 1, they agreed that D will give C land and C will give D 10,000 pesos if C passes the SPALE on November 30. So here comes C passes the SPALE, which means D is now obliged to give C the land and C is now obliged to give D 10,000 pesos. Now, in the principle of retroactivity, Article 1187 states that the day of the agreement must be acknowledged as the day of the ownership of a thing. For example, here, okay, which means this land here is owned by C since August 1, since they agreed on August 1. So, even though C passed the SPALE on November 30, the land is acknowledged to be his on August 1. And accordingly, the 10,000 is D's. The owner of 10,000 is D because the principle of retroactivity. Because they agreed that the 10,000 will be given to D on August 1. The date of the agreement of August 1. So like, what we need to take importance here is the day of the agreement. So since they agreed on August 1, the ownership is acknowledged on August 1, even though the condition was fulfilled on November 30. That's the principle of retroactivity. Now let's go retroactive effects as to obligations to give, or that's what I talked about earlier. Okay, now let's talk about obligations to do or not to do. So let's say if let's say if C passes the Sepale, his debt to D is extinguished. Let's say before that, C borrowed 10,000 from D, which means C has a debt. So if C passed the Sepale, D said that his debt will be extinguished. So let's say he passed the Sepale on November 30 and they agreed on August 1. So it is important to acknowledge the retroactive effects, which means since August 1, his debt or C's debt is extinguished because their agreement is the debt will be extinguished when C passes the Sepale, and they had the agreement on August 1. Therefore, since August 1, as to the principle of retroactivity, C has no debt. Okay? Now we're going to talk about as to the fruits. Okay, let's go here to the land and to the 10,000. Okay, let's say this land had fruits, example like a mango, okay? And since the land is owned by C since August 1, let's say a mango was harvested on August 30. Okay, on August 30, a mango was harvested. Okay, and then here comes C passes. So that means his land since August 1 is the owner of the land is C, right? So the fruits of it is also C's, right? It's also his because the fruit was harvested on August 30. Now let's also consider, since the 10,000 is D's ownership, like D owned the 10,000 since August 1, but the money was held onto by C, which means it is a debt. It is a payable. It is payable to D because C has the money, which is D's money since August 1. Okay. Now, since C has a payable, has a debt, of course, if there's a debt, there is an interest. So let's say since August 1 to November 30, that's quite long. Let's say they had an interest of like, theoretically the interest is 500 pesos. It means that C must not only give 10,000, but he must give 10,500 to D. Okay. C receives the land and the fruits, the mangoes, and D receives 10,500. But Article 1187 states that the fruits cancel each other out, which means D will get to keep the mangoes and C will not pay the 500. Get it? D will have the mangoes and C will not pay the 500. So like they both offset each other. Okay. That's Article 1187. Now let's proceed to Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions to preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. Okay, let's say let's say let's go to the same example. D gives land to C, and then C gives land to D. Okay, same example. If C passes the Sipale on November 30, 2026. Okay. Now, C will receive the land if he wins, right? Or if he passes. So, C can go to the court. He can go to the court to file a case to exercise his right, wherein he says that D must not sell the land or give the land to any other people, because the article states so. You can exercise your right. C can exercise his right. Okay. Next, the debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. So as we can see here, this is a bilateral condition. D gives land to C, which means D is the debtor, C is the creditor, and C gives land to D, which means C is the debtor and D is the creditor. So like, let's say, no, it's not give land actually. I made a mistake. It's actually give 10,000. Okay. Let's say C accidentally wires the money to this bank account, like on August 30. Let's say on August 30 he accidentally wired the money to this account, when in fact he is obliged to give that on if he passes this Sipale on November 30. So C has the right to recover what he lost, like in the article for quasi-contracts or dissolution indemnity, the payment by mistake. By that, D is obliged to give the 10,000 to C because the obligation still has not arose. Okay. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of improvement, loss, or deterioration of the thing during the pendency of condition. Let's say D will give car to C if C passes the Sipale, okay? Just like our preceding examples, except it's not give a land but give a car, okay? Let's say there was an earthquake, a thunderstorm, or a flood, and then here comes the car is ruined. So we can say that the the earthquake, the thunderstorm, or the storm is a fortuitous event. And then, why? Okay. Okay. The earthquake is a fortuitous event. It is out of control of D. Therefore, D is not liable, and the obligation to give the car is extinguished because there is no car to give anymore because it is ruined during the flood. Now, if ever the car was lost and D contributed to the loss, like D contributed to the loss, like example, it was because of his negligence, then he is liable for the liable to pay the damages. Okay. Now, if example the car like the paint of the car faded, which means it deteriorated by nature, like naturally, and the impairment or like that loss is shouldered by the creditor because it is not the debtor's fault. However, if it is due to this negligence, example, he left the car out like under sunlight, under rain, under whatsoever, naturally it will fade, right? So D contributed to the deterioration of the car. That means he is liable for the damages. Okay. If the thing is improved by its nature, let's say the car improved like naturally improve, right? I don't know when a car will naturally improve, but let's say theoretically it improves, then the benefit will be shouldered or like will be borne by the creditor. Okay. Now, if it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Let's say during the obligation or like before the obligation happened, let's say on August 30, he changed the tires or like put on like new seats by his expense. Therefore, when the obligation happens, he can get those tires and those seats, provided that he will return whatever like the previous tires and the previous seats. That is the usufructuary, the tires and the extra seats. Okay. Now, how can we apply the Article 1189, the requisites? First is the obligation is a real obligation, which means it is an obligation to give. The obligation is a specific or determinate thing, in which I said a car, and then the obligation is subject to a suspensive condition, in which I said that D will give the car if C passes the SIPALE, which means it is a suspensive, and the condition is fulfilled. So the condition is like C passed the SIPALE. There is loss, deterioration, or improvement of the thing during pendency of the condition. So like either there is loss, there is deterioration, or there is improvement. And then we can apply Article 1189. Okay. Now, before going to after 1189, we're going to talk about the kinds of laws. We have physical laws, legal laws, and civil laws. Physical laws happens when a thing perishes just like a house is burned or reduced to ashes, which means it is not physically there anymore, like we can see it. Legal laws when a thing goes out of commerce. For example, during the World War II, I think the Japanese said that the US dollar is illegal, or like it should not be provided anymore, it should not be produced. Therefore, it is legal cause because legal loss because the dollars went out of commerce. Now, civil laws, when a thing disappears in such a way that its existence is unknown. Let's say your dog is lost, you don't know whether he died or like he disappeared. Or for example, let's say you lost this ring, I lost this ring, like I don't know when. Let's say in the sea, I lost this ring in the sea, so I don't know the exact location of the ring, but it disappeared. So it is a civil loss. Now, let's proceed to Article 1190. When the conditions of the Article 1190 talks about the return of the items involved in the obligation. Let's say a resolutory condition. Okay, let's say D will let C borrow his car until November 30. Let's say, okay, which means C can borrow this car until November 30. Let's say when November 30 arises, like the obligation to like let's see borrow is extinguished, right? Because it is November 30. However, another obligation is acquired. C is now obliged to return the car to D. Yun. Article 1190 talks about like the returning of what was received during the obligation. That's about Article 1190. So if it is obligations not to do, the court shall determine the retroactive effect of the fulfillment of the resolutory condition. It is the same with Article 1187. Where is it? Let me find it, okay? Here. In obligations to do or not to do, no fixed rule is provided, which means it depends upon the courts. Okay, now we still haven't talked about unilateral obligations, okay? This obligation, like D gives C and C gives D, is a bilateral obligation, right? As I mentioned earlier. Now let's say D will give C a land. If C passes si Pale. No other information. Okay. Let's say on August 30 there were mangoes. And then C passes si Pale. So like the fruits are now owned by D. Even though with respect to retroactivity, the mangoes should be owned by C, right? But this is a unilateral obligation, which means the land is given, it is donated to C, which means the article says that it is only fair that the debtor will have the fruits, because in the first place it is a donation, it is a unilateral obligation. So that sums it all up about our topic of law and obligations from Article 1179 to Article 1190. I hope you understood and somewhat enjoy the brief explanations and discussions we have. So yeah, bye.